1951. This is The Legend. 105.3, 95.3, WDXE.
That's us, and it's time for Bulletproof Estate Planning with your host, Dan Pierchoski. And I just kind of hang around for the fun of it.
Good morning, Jeff. You are correct. It is time for Bulletproof Estate Planning.
That's right.
And I am your host, Estate Plan Stan.
That's right.
And I appreciate you hanging around for the fun of it. I hope
Yes.
the key word there is the fun of it.
It is the fun. I've seriously, I've learned a lot, and I even have people ask me about you and the show, and then and sometimes ask me, well, what should I do? I was like, well, call Stan.
You can always pull the "I don't give legal advice" card, you know.
Yeah. I don't give. I actually had, of course, it happens in the business that I'm in. People are handling their estates or their property, and they're planning those kind of things. So I'm in that arena, but I'm not a lawyer. So
right. And now, real estate's a real big factor of it. We see a lot of stuff happen with real estate.
Yeah.
Usually, real estate's pretty much the lion's share of a lot of people's estate.
Yeah.
There's always some in there. You get the people that have rental properties, or you get the people that have many acre farms and stuff. It's a lot of agricultural property. So real estate is a big factor. Yeah. And it's a big factor not just owning it. It's a big factor in how they use it, how they want to pass it on, stuff like that.
The question yesterday had to do with taxes. If I do this, how's it going to affect my? And of course, I'm not in a position to give tax advice either. So we have to. And
I don't
have to appeal to an expert.
I don't take the approach that I'm a tax attorney.
Yes,
I understand how a lot of it works.
Yeah,
but I'm not in a position to give particular and specific advice. Your tax people are trained in that, and one of the reasons a lot of that stuff is in motion all the time.
Sure.
And I don't keep up with it. I keep up with my, my wife says, stay in your lane, right?
You stay in your lane.
I have my lane. It's estate planning, and I get the concept of taxes and their impact in the generalized view of things. But as far as, if you want to fill out your tax return and claim this or don't claim that, I hire people to do that for me. So.
Yeah. Well, that's what a lot of this is about. In my business and your business is you've become an expert in your lane. So people can come to you with those kind of things and say, look, I'm handling this. What do I need to do?
And it's experience is the mother of education. I swear to gosh, you can read books, you can listen to me, tell you what the law says, but it's the actual people's experience, and when we do things, when we do trusts or we get people qualified for 10-care and deal with 10-care, that's where the real learning occurs.
That's
when you're jumping into the deep end of the pool, because I swear to gosh, it is we see something new every week. And sometimes when I'm just about ready to say, "Man, I've seen it all," I haven't. And in a weird sort of way, I love that about this area because it presents itself with challenges, fresh thinking.
Sure.
I'd hate to be in a cookie cutter kind of field where it's the same thing over and over all the time.
Right.
So I think it's exciting. I think it's stimulating, and it gets fun when we're dealing with stuff comes up out of nowhere. And it's like, well, I never saw that coming.
Well, I'll ask you about this aspect of your business, since we're kind of talking in general here. It is for me anyway. Is you get to meet a lot of people.
I do.
And so you have to kind of enjoy meeting people and learning of their story, learning about what's going on with them, which helps you help them make decisions.
Yeah, I mean, you're right. We sit and talk with a lot of folks who want to have one of my family vision meetings, or people just call about certain questions. I talk on the radio about the phone calls I'll be glad to schedule if you want to ask questions. Yeah. And eventually somewhere along the line, either in the beginning when you're just breaking the ice or something, somebody will mention something like, "Oh, my son went to school with your son," or I used to be an engineer like you too, or I'm an engineer, or my kids are engineers, stuff like that, and it just sort of makes a little connection there because you get something to talk about. And it is fascinating. Some of the people I run into, if not most of the people I run into, are just very interesting. Yeah, get talking to them, and they're. And I'm going to hand it the average folks around here, and I'm going to limit it to around here because not just because that's where I'm here, but I really believe it, in this basic neck of the woods, people are pretty darn smart. Yeah. And sometimes they don't always come across that way, but they are. Yeah. They are smart. They have a ton of common sense. And they tend to, and their common sense and the wisdom they do possess seems to, 90% of the time lead them in the direction of doing the right thing. Yeah. Now, you always got your rogue element and people that just, can't do the right thing. They're just hardwired that way. You know what I mean? But I often something when I talk to people, sometimes it can be emotional. I really feel for people sometimes.
Sure.
You get people that have got good fortune, they've been blessed, and things are working well for them. But maybe more often than not, you get somebody that will say, I got a child and they're just completely estranged. We don't know why. They married this person. Now they want nothing to do with the family. I mean, the parents, they won't call them. They won't talk to them. Or that's just an example. There's all kinds of things. Or somebody gets in some kind of legal trouble.
Sure.
And they got to go stay in the, in the governor's hotel.
in the pokey.
or something, And, it's when somebody tells you stuff like that, my heart just goes out to them.
Yeah, absolutely.
You can't help but put yourself in that position.
Absolutely.
And say, if one of my kids estranged me, I mean, that would be almost a fatal blow to me. I have a real hard time handling that. Yeah. And so, and those are real life concerns that are going on in their lives. And fortunately, with what we do, and if we're there talking about estate planning, that's the umbrella in which those things come out under. Yeah. And so we're looking at ways to deal with our estate plan that brings those circumstances in. What we're going to do, I can't really fix the problem. If somebody's estranged, I often say I wish I could help you with that. I don't know if I can, but depending on what you want to do about it, we can work that in. Somebody says, well, if they're estranged from me, then I'm just not going to leave them anything.
Well, I think I've gotten to know you well enough in these visits that I feel like that you would know what I mean when you have rewarding experiences when you feel like you've helped somebody.
True. And it is. That's where the fun is for me.
Yeah.
When a problem comes along and it's unique, I mean, although it's a serious issue, right?
Yes.
Especially, and really these things come up in mostly in the TennCare aspect.
Yeah.
Dealing with, the trusts we write and doing like that. I mean, there's certain issues come up, but when something comes up in a TennCare aspect, it's usually a serious issue. There's a lot of money at jeopardy or something like that.
Right.
And although I don't ever forget the seriousness of it, when a problem comes up, I usually feel like a kid in a candy store in a way. It's like, okay, I look at my schedule and say, when can I find a free hour or two that I can research and dig into some statutory authority on this and find out a way to fix this? It's just a fun. That's what I find very rewarding. Yeah. And then I can come up with a solution and offer to them.
Yeah, absolutely.
I was actually going to talk about an example of something like that where we came up with a solution to a very difficult problem. And the reason I want to use it is because I often talk about this very concept, but I never had a really good real-life example to compare it to. And so I have one now, and maybe that'll help people understand the concept. But
good.
Before I get over it, let me go over some of the introductory stuff, and that is we've got a seminar coming up.
Oh, yeah.
A little less than a month now. It's May the 18th, right here at WLX in the back of the building. And
at the Country Cafe here, the studios behind the studios here.
And the Saturday seminars, we always start at 10 o'clock, pretty promptly at 10. And we call it Wills, Trust in the Nursing Home. So if you want to come to that, give my office a call, 931-363-7222. Go to my website, Estate Plan Stan. You can RSVP from there. Let us know you're going to come. It's pretty informal RSVP. Let us know if you want to come, how many people are coming. It's still almost a little less than a month out. But
would highly recommend it.
And we're starting to do this a little less often. The last one we did was a month before April,
Right.
March, we did one in Pulaski. And so we're skipping April.
Right.
And we're going to do this one here. So if you're interested in that, that's enough time ahead where you can look and maybe put on the calendar and come. A lot of people enjoy those and get a lot out of them.
Yeah. So. And this morning, of course, the phone lines are open. If you'd like to talk with us here or talk to Stan, 766-9393 is the number.
Yeah. Okay, so this example I want to talk about, we talk a lot about this asset protection trust that we do and how it protects property. And, it protects property. When we say asset protection, a lot of folks may be neutral about that term. It's like, what does that actually mean? Sometimes I use the term creditor protection. And that's what we're really doing when we have an asset protection trust is we're putting property into a trust and protecting it from your creditors. Now, usually the response is, well, I don't know anybody anything right now. I don't, that's not the creditors we're talking about. We're talking about future creditors. And the future creditor most people are worried about is long-term care, because it's so expensive. So we put property in trust to protect it from that future creditor should that future creditor become an issue in our lives. Because, dying's a when. Going into long-term care is an if. So we don't know. You and I don't know if we're headed there. But if we do get there, we want to be prepared for it. The way you're prepared for it is you have property in trust that they can't get at to make you use to pay for the cost of care.
Yes.
Like the real estate we talked about that's so important to so many families and stuff. So now, what if you don't protect this property? And this, I'm going to make this analysis and base it with the facts of an actual case. And some of the misinformation that we deal with is people think that, well, if if I'm going to go into long-term care and they're just going to get everything, why can't I just give it away? Why don't I just start giving it to my kids? And that way, when it comes time to pay the bill, I just say, I don't have anything. I don't have anything to pay with. Would be nice if it worked that way. I mean, just ditch everything you own at the 11th. It's kind of like, it reminds me in scriptures, is it okay to just sin, and then if you're on your deathbed, just repent?
Yeah.
I think the way it's taught in scriptures, you can do that. I would highly not recommend it, though. but so can we just wait till we feel bad? We know we're heading for the nursing home, and if we are, just dump everything and give it away. Well, before the ink was even dry on the Federal Medicaid Act,
that's very risky.
That was thought of. Okay, that is not a new creative thought.
Yeah.
And the answer is yes, you can give it away, but if you give it away, there's some baggage that goes with that. And it's kind of unpleasant baggage. But sometimes we work that in if we can make it work. But the baggage is when you give something away, the law presumes. When you have a law, there's a presumption. It's rebuttable, but that's a tough one to rebut. But there's a presumption that if you've given something away and you've done so in a certain time period, and the time period is within 5 years of going into long-term care.
Yes.
So if you've given something away, and when I say giveaway, we're talking about an uncompensated transfer, meaning you're not getting anything for it. You can sell something because you get money for it, right?
Right.
But if you give it away and say, here's my house for love and affection, it's yours. I mean, your house is worth a couple $100,000. They didn't pay you for it. You're just giving them. That's what I'm talking when I say gift or giveaway.
Yes.
Uncompensated. So if you give, the presumption is if you give something away, or if you have what they call artificially impoverished yourself, meaning you're not broke, but you're making yourself broke, right? So if you artificially impoverish yourself by giving something away within that time period, they can punish you for that and impose a penalty period.
Yes.
And a misunderstanding of folks is that penalty period is not capped at 5 years. 5 years is how long they can look backward to see if you've done this.
Yes.
The penalty period is based on the value of what you've given away. So there's no upper end to that.
Yes.
So if you give away a $2 million farm, you're looking at a 20-some year.
Yes.
I had a case where the penalty period was 604 months.
Yes.
Which is a long time.
That's a lot longer than 5 years.
So there's no cap. So we need to understand that to some extent. So, and that's the crack you can get your tail caught in if you give stuff away just before going in. Because if you do it just before going in, it's surely within the 5 years.
Yes.
And now, if they can, when I say it's not that you can't give stuff away. You just need to know if you do, they're going to impose a penalty period based on the value. And of course, the penalty period is a term of months of ineligibility. Even though you're eligible, you can be eligible all across the board, medically eligible, income eligible, and resource eligible.
Yes.
But they can impose this penalty and say you are eligible, but for the penalty that you created by gifting this stuff away in the last 5 years.
Yes.
And so it's like I said, so it's a period of ineligibility saying, okay, you gave away this money, you got a 30-month penalty period, which means, hey, we'll pay the minute the 30 months is over with, we will pay.
Right.
But we're not paying for the 30 months because had you not given this stuff away, you would have had it to pay us. See, TennCare's position doesn't change. If you have assets, they make you use them to pay, and therefore TennCare doesn't pay.
Right.
If you give assets away, they're going to say, well, you could have used them, so we're not going to pay for the penalty period of how much you could have paid. So they don't pay. So their position always stays so they don't get hurt. It's not as simple as giving it away and then saying, sorry, I can't pay. I guess you'll just have to. It's like, no. And if you get a penalty period, that's a problem because if they won't pay, the choices are this. You private pay. That's number one.
Yes.
But I don't know. Can you private pay? You gave your stuff away. You may not be able to private pay.
Yeah.
Okay? Now, or two, you don't get care. Pretty harsh result.
It is a harsh
We sure
decision.
don't want to be there because if you need now, some people say, "Well, my kids will take care of me." Now, I contend that's not a choice; that's their choice. And even if it is their choice and they choose to do it, nobody wants to put that burden on their kids. I mean, I can't imagine anybody just saying, "That's all right. I'll just let my kids take care of me." I mean, the hope is they will help look after you, but you don't want to be a burden to them either. But anyway, so you don't have much in the way of choices, and it's a bad place to be.
Yeah.
So brings me to the real life example. You know, we have somebody that gave away some real estate, and it was, a fair amount.
Yes.
Not all of it. They had, some people have their primary residence, is what we
Yes.
want to call under the language of the statute, your primary residence, and then they have what they call other real estate, which is everything other than your primary residence. And so they gave away this other real estate to family members, 3 or 4 months before being admitted.
Oh,
so
wow.
Clearly, I mean, if I was in TennCare, that's clearly somebody who is gifting away property for purposes of eligibility, to make themselves eligible.
Yes.
And that's where the prohibition is. So they imposed this penalty period. It was a big one. It was 51 months, okay? Which is not it's based on the value. You take the value of what you've given away and divide it by the number 8,220, and that gives you the number of months that they won't pay. And it's kind of that 8,220 is supposed to be loosely based on the average cost of care. It's a little low, but it's better than it's been in the last several years.
Yes.
But so we get this penalty period. Now, they've created that. Now, here's the situation that makes it a big problem. The remaining assets, okay, are not enough to private pay for 51 months. So we got this penalty period, and we can only private pay for about 20.
Oh, wow.
And that will just exhaust everything. Okay.
Yeah, so that wipes them out.
So now we're really in a bad position because we're wiped out. TennCare won't pay, and we still got 20, 30 months to go. Okay, so that's definitely So when people say, worry about giving stuff away, that's always a red flag to us because if you create a situation like this, it's a tough place to be. We don't want to be there.
Right.
We avoid this penalty period. There's ways we can work with it. So, the question is always, can I give it away? The answer is yes, you can give it away. The next question is, should we give it away?
Yeah.
Let's wait and let's look and see what the effect of that's going to be. Can we live with this penalty period? Yeah. If it's a small amount of money and a small penalty period, a lot of times we do just take the hit,
Yeah.
Because you get a month for every $8,220. So if you can only give away $5,000 and you got a 2.5 to 3 week penalty period, we might just take that and not worry about it.
Right.
But when it gets into these months and months and years of penalty period, you're talking about some serious money. So now we got a situation where there's no recovery from this situation. So they come to me and I'm thinking, okay, this is a bad problem. We got to find a solution for it. Fortunately, I was able to do so.
Well, this is going to be fascinating.
So I dig into it, and you've often heard me say, well, in Tennessee, we're one of the few states that allow you to cure a penalty period. Now, what I mean by that is, let's say you give away $82,200. I picked that number because that would be exactly a 10-month penalty period.
Yes.
Okay.
10 months.
So you gave your kid a check. Here you go. Here's $82,200, just because I want to give it to you. And then you go into long-term care and they say, what happened to this $82,200 that came out of your bank account? I said, well, I gave it to my kid. Did you get anything for it? No, I just gave it to him. Okay, well, that is a divestment. That is an uncompensated transfer. We are going to impose a penalty period.
Yes.
Now, I like to use the word punishment because I think it's a better word, but they imposed 10-month penalty period. Okay,
Yeah.
So now, if we're talking about me, now I go back home and I think, oh, shoot, I'm stuck with this penalty period now. So I call my kid up. I call my son up and say, hey, they're going to hammer me with this 10-month penalty period. Can you give me the money back?
Yeah.
Okay. Now, let's just suppose my son says, sure, Dad. Well, let's go the other way. He says, no, I've already spent it. I'm sorry. I just don't have it. It's gone. Well, I'm stuck with that penalty period. I am just stuck with it. But suppose he says, yeah, sure, Dad. I mean, you gave it to me as a gift, and I don't really need it. And if it'll help you out, I'll give it back. So he writes a check to me back for the $82,200 and gives it to me.
Yeah.
I have cured. Now the penalty goes away. There is no penalty. The gift has been cured.
Yes.
Because TennCare's position is this. Okay, we'll cure the gift. Well, I mean, the penalty will make it go away. Because now you have the $82,200 asset that you can use, that is now available to you for cost of care.
Yes.
So they're not. They don't mind curing the penalty because they're in the same position.
Yeah.
The penalty says we're not going to pay because you could have, So we're not out anything.
Okay.
Now, if you have the asset, you're going to pay because you can,
So then
and we're still not out anything.
You got to use that.
That's
Then
right.
you'll have to use those funds.
That's right. So, but my position is we're better off having the funds and dealing with them than we are dealing with the penalty period.
Okay.
So here's the situation we're in this case. We got this penalty period, and it's a tough place to be. I'd rather have the property back.
Yeah.
So we approached the people we gave it to. Let's just say there's one person.
Sure.
And of course, now we need their cooperation. We need to get it back to cure the penalty. Well, before I go there, let's say my son could only give me half of it back.
Mm-hmm.
Tennessee also allows partial cures. So if I got half of it back, I would have at least reduced the 10-month penalty period to 5. They'll let you reduce, you know what I mean? Because now the gift was only was only half that.
Right.
Okay, so they will let you do partial cures too. In case, if I gave money, so I spend some, but I still got half left.
Right.
I'll give it back to you. Which is an advantage we have here in Tennessee. A lot of states don't let you do that. It's just uncurable. Once you give it away, even if you get it back, you still get the penalty period. Now that is rough.
Yeah. Okay.
So, but we don't do that yet. So that's an advantage, and we can use that a lot of times. So the theory is, okay, let's see if we can get this property back, either by deed or have them pay us for it. Okay. Now, stay with me on this, because right off the bat it sounds like, well, what if the person can't pay for it or something, or what if you gave it to him and he already started to build a house or something like that?
Sure.
They already got some skin in the game. Well, here's what we can do. We can structure it to do this. Let's give it back, and let's say we do it with funds. And the person says, well, I don't have that kind of money. Well, how about, can we finance it? So we get it financed.
Right.
We give the money back to the person. So now we got the person that donated the property back, essentially, right?
Okay.
Now we have the assets. So what we're going to do with the assets, now we can divide them up and protect, if we're a married couple, we can divide up a lot of assets and protect under our impoverishment rules. And now we can take a lot of the money and annuitize it into what we call a Medicaid compliant annuity. And that will pay to the healthy spouse. So we got a sick spouse in care. We'll annuitize these funds. The funds are going to be largely what we got back from the house, okay, and some of the other funds that the couple had in the first place. Okay. So we'll annuitize it in a spousal annuity, so it will pay from the institutionalized spouse to the healthy spouse or the community spouse. And what we can do is we can structure those payments so that as that annuity, and we'll do this pretty quickly, like in a matter of 2 years or 3 years, we'll pay it back quickly. Mm-hmm. And what we can do is we can structure that a portion, if not all of those annuity payments, once they go to the healthy spouse at home that's not in care, can then be funneled directly to the person that donated the land. So over the period of time of this annuity, we can make the donor of the land whole again.
Okay.
And they're back to where they were when we started.
Okay.
The land is back to being them. They're there. They're not out any money.
Yeah.
It just had to go through this, give it back, and then we're going to give you your money back and give you the land back to satisfy the requirements. And that will fix it. And that's the solution. Now, I don't call it the most ideal solution because it relies on other people to agree to do it, which makes it a little bit out of our ability to control. But it's the cards I'm dealt on this case.
Sure.
I've got to deal with these people. Fortunately, in this particular case, they are family members. They're certainly willing to cooperate. And these things weren't gifted very long ago. I said about 6 months later, we're in the home, right?
Yeah.
And the family knows and understands why it was gifted.
Right.
And, they just didn't understand that it was going to cause this effect. They're under the impression that, hey, can you sell this land to pay our bill? Well, it's not mine. It belongs to my child. Sorry, I can't do that.
Right.
And they didn't understand this consequence until I spelled it out to them. When I spelled it out to them, it's like not only are you going to be out of money in 20 months, but your spouse at home is completely impoverished once you reach that point.
Yeah.
And that is exhausting everything. Now, the spouse at home has nothing to live off of.
Right.
So, it's the worst of all worlds. It's really so when you say, can I give stuff away? Yes, you can give it. There's no prohibition to giving it, but you really ought to understand the baggage that comes with that and then make your decision, because should you give it away? It's usually not the best idea.
No.
Sometimes we can make the penalty period work. This was not one of those cases, but we made the cure work for us. And so we cure the gift, and then we deal with the assets that we now got back, and we can save 100% of those assets, because we're a married couple and we can turn it in from all those assets, which are countable assets, we just simply turn them into a non-countable stream of income, problem solved. So that's what we're working toward on that. Now, I say that example, and I said I wanted to have a real-life example. It wasn't so much for that as it was to compare it to something else.
Okay.
Suppose we didn't give it away to our kid. Suppose a time earlier we made our asset protection trust. Okay.
Okay.
We put it in trust. Now, make no mistake about it. When you put property into one of our asset protection trusts, you are giving it to the trust. I want to unpack that a little bit. So we open a trust, I often say, if you're in my office and I'm explaining stuff, I'll draw on the whiteboard a box and I'll say, here's your trust. And then I'll draw a picture of a little house and an arrow, and we're going to move your real estate inside the box, right? It's into the trust.
Right.
So when we do that, we draft a deed where, you, Jeff Hood, the individual, retitles his property to Jeff Hood, the trustee of his trust. And that's what takes it from outside the box and puts it inside the box. Now, when that happens, the trust doesn't, it's a $300,000 house. The trust does not fork over $300,000 and pay you for it. You put it in there and you get nothing in return as the individual, okay?
Okay.
Because first of all, if the trust paid you for it, you would not have advanced your position one iota. You have a $300,000 asset in your personal name available for the cost of care. If you receive a $300,000 check for selling the house, you still have a $300,000 asset available for the cost of care. So your position has not changed at all. We've not protected anything.
Right.
But if we move the house into it, the theory of the asset protection trust is you put the house into it, and it's now that is in TennCare's eye an uncompensated transfer because you changed ownership, and you didn't get anything for it. Okay.
Yeah.
Now, that is not trust law and has nothing to do with trust law. It has everything to do with the TennCare Act. It says if you're going to give something away and artificially impoverish yourself, i.e. make it unavailable to us for the cost of care, and you do so by giving it away, we are going to impose the penalty period.
Okay.
So, the theory is when you put it in the asset protection trust, the very minute you put it in, you've changed it from countable to non-countable. And you've heard me talk about countable assets, right? Got to have countable assets less than $2,000.
Yeah.
Countable.
Right.
Countable is not the only category of asset. Now, if you can have countable assets, does it not stand to reason you can have a non-countable asset?
I would say
and the
so.
answer is absolutely yes.
That's right.
And so the minute we put it in one of these asset protection trusts, it has changed its posture to non-countable. It is no longer available. But is it protected? Well, yes. TennCare can't touch it. They cannot get at that property. So if you've given it away to your kid, they can't get at it because it's not yours anymore.
Right.
But they can punish you for doing it.
Okay.
See, here's the overlap between the trust and this penalty period. The trust doesn't recognize the penalty period at all. But what happens is TennCare says if you give it away, we can punish you.
Okay.
And when you put it into the trust, you are technically giving it away.
Okay.
Okay.
So quick question. So
Okay.
the same thing applies when you put it into the trust. There's still a 5-year waiting period.
They can still penalize you for changing ownership without getting compensated for
Yes.
it. Yeah.
Okay.
Yes.
Okay.
That's why I say when we do this trust, the goal, number one goal, is put your property in the trust and stay the heck out of the nursing home for 5 years.
Yes.
That's number one. But there's really two things going on there.
Sure.
Once we put it into the trust, it's protected.
Yes.
The problem is the TennCare Act says if you make something non-countable by giving it away, we can impose this penalty period if you've done so in the last 60 months.
Right.
And so there's the overlap. So it has nothing to do with trust law, but it affects the trust.
Yeah.
Okay. So now let's just suppose this is scenario. I'm talking about a scenario where we end up going into the long-term care long before the 5 years gets reached.
Yes.
So we put it in trust. Let's just take this case.
Okay.
You put it in trust, and 6 months later, very early in the 5 years, everything goes south, and you get admitted to long-term care, right? And you come to me, and I say, boy, I'd rather have the asset than the penalty period, because we're going to get the same 51-month penalty period for putting it in the trust, because it was the same amount of money that we put in there.
Right.
But the big advantage now is we control the property in the trust. We don't have to go to the kids and beg them to please give it back, or run the risk of them saying, I lost half of it in a divorce, so I can't give it back to you.
Right.
I can come up with a million examples.
Those life circumstances.
Yeah, I mean, you don't know because you've given it away, and now it's subject to whatever comes down the pike, or them just saying, I'm not giving it back.
Yeah.
Or, gee, I invested $200,000 and built a house on this thing.
Yeah.
I can't give it back. Whatever. But let's just say we can't. But it's in a trust for our benefit now. We control the trust. We have complete control over the assets in the trust. So we can unwind the trust, back out of it, and now we have the assets. We've not letting the asset get away from us.
Yes.
It got away from us to the effect that we divested it to the trust, but we are still controlling the trust.
Yes.
So there's a big advantage. Now, that's just a advantage of doing this, because when people say, well, if I put it in trust and I'm facing the 5-year rule, Why don't I just give it to my kids and face the same 5-year rule? And the answer is, that logic is sound, but it's not complete. You're right. You're still facing the same 5-year rule if you give it to your kid or you give it to the trust.
Right.
But there's more to that story that makes putting in the trust a more palatable option from a legal standpoint.
Yes.
We want to maintain that control because when people say, I'm just going to stay out of the nursing home for 5 years, well, easier said than done. I plan on staying out for 5 years. I plan on staying out for 20 years.
Yeah.
Are my plans going to be fulfilled? I don't know. I don't have complete control over that, do I?
That's right.
So, but if something happens, I want to be in the best position I can be in.
Sure.
And that's the advantage of the trust if we don't make our 5 years. Now, if you make the 5 years, there's still advantage to it just being in the trust because we're still controlling it, but we've escaped all that jeopardy of them going after it or them imposing a penalty period.
Right.
So so when folks say, well, if giving it away and we put it in this trust, we still get the 5 years. Well, I'll just give it to the kids now and still get the 5 years. Well, you can do that.
Yeah.
I don't advise it because it's out of our control, and I have seen instances where we can't get it back, mostly with money.
Yeah.
People say, I've been giving away $15,000 to 10 family members every year because IRS says you can do that. So I've been giving it away. Well, when they get to the long-term care scenario, and they're very shocked to find out that TennCare is going to say those are all uncompensated gifts, and we're going to punish you for it.
Yeah.
They actually get irate and say, but the IRS said we could do that. Well, They didn't say that. They said you just didn't have to file a tax return. A gift tax return if you do that.
Yeah.
IRS is the IRS. That's not TennCare.
Yeah.
It's a fundamental thing to understand. TennCare is not the Internal Revenue Service.
They're not the same interest.
And the Internal Revenue Service is not TennCare.
Yes.
All IRS says you can give this away and you don't have to file a tax return. Let me back up. You don't have to file a gift tax return.
Right.
Big difference. And if I have time, I'll talk about that today. TennCare is going to sum them all up in the last 60 months and say every one of these is a divestment because you gave it away, you got nothing in return.
Yeah.
We're going to punish you for doing that.
Yeah.
And they are fully within their rights to do that. And it shocks people who do this to find out that that's what happens.
Wow.
So I talk about it on radio shows. I talk about it at my seminars.
Right.
And I might as well talk about it now because I brought it up, because I finished the example I wanted to get.
Sure.
So it's much better to put it in trust and maintain control over it.
Yeah.
So, but I digressed a little onto this topic, and I think it's an important one because a lot of people are deceived by this.
Yes.
And when I bring it up in my seminar, I see a lot of people starting to sweat at their brow because they've done this and thinking, uh-oh, now what do we do? Okay, so, the IRS says, I think it's up to $18,000. It changes almost every January, but not always. And they say you can give away $18,000 to a bunch of different people per person, and I think it's unlimited number of people per person a year, and you do not have to file a gift tax return. And that sounds like a big advantage to folks. Like, wow, we ought to do that. Well, let's nuke it out. You can give away more.
Yes.
It's not, the prohibition is not $17,999.99, which is what I see people writing checks for.
Yes.
The prohibition is if you can give away $30,000, you just have to file a gift tax return. Now you don't pay a tax. You're not going to pay a gift tax. It's an informational return.
Okay.
Because they want to keep up with your lifetime gifts. Because if your lifetime gifts, the sum of your lifetime gifts, and the value of your estate at death that you hadn't given away, if that exceeds the federal exclusion allotment of $13.6 million, then they're going to impose the estate tax on you.
Yeah.
So they don't pull it back literally into your estate. They pull it back number-wise.
Right.
So they're not going to call your estate what your estate is at death. They're going to call your estate at death what you have in your estate at death, plus all the lifetime gifts you've given. And the way they keep up with your lifetime gifts is you file a gift tax return.
Yes.
Now, what they're saying on the $18,000 is they're saying, you know what, that's de minimis. We don't really want to keep up with them if you're giving away that little bit. It doesn't sound like a little bit to me, but they say you don't have to do a gift tax return because we're not going to bother keeping up with it.
Yeah.
So when people hear that, they think there's this great advantage, and they make the mistake that it's a great advantage for TennCare. So they give this stuff, and they say, okay, here's a way where we can give it away, and we won't be punished for it. So they give it away, and And again, the fundamental concept you don't want to lose sight of, the IRS says you can do that, and they say the only advantage of doing that the IRS gives you is you do not have to sit down and file the one-page, very simplistic gift tax return. Because they think there's a gift tax associated with. There is not. Even if some gifts in your estate exceed the $13.6 million at death, it's not a gift tax. It's the federal estate tax. That's 40% of every dollar over $13.6 million.
Estate tax.
And so there's no gift tax in there.
Yeah.
And it's just the return. And like I said, a return just says I've given away this much money. And so they can include that in your estate at death to see if you owe the estate tax. Now, 99% of the people around here don't hit the 13.6 million or the 27.2 if you're a married couple. Some might, but you know what I'm saying. The average people don't. And so there's no advantage to that. But if you make the mistake that will get you off the hook and you can give stuff away and whittle down your estate so you can be eligible for TennCare, it does not. So now you've given away money. Now what's available to us? Well, the cure is still available if we can get it back. But you know what's really hard to get back is money. Because you go to the people and say, hey, do you still have that $18,000 I gave you? I need it back. Oh, man, Joey's tuition was due at college, and we paid it. We don't have it. Or little Susie's braces. We got braces for Susie. I've heard it all. It's very difficult to get the money back. Sometimes we do, but by far, it's and so we're more often stuck with the penalty period when you gift away actual money.
Right.
Real estate, it seems like I can't really think of a scenario where we couldn't get it back.
Yeah.
I remember some resistance, but for the good of the family, it always came back.
Yeah.
But money, if it's gone, it's gone.
There probably are scenarios where you couldn't get the real estate back.
The question is, how do I fix that? How can I fix? Suppose I'm not giving away $18,000 to my kids every year because I want to avoid filing a gift tax return.
Right.
Suppose every year I just have this prior course of conduct where I give everybody $10,000 at Christmas time or whatever.
Yeah.
Do you mean I have to stop doing that because it's going to just jeopardize my long-term care if I ever go into it? And the answer is, if you keep doing it, the last 5 years of it, when you go into care, will be a concern, right?
Yes.
So now the question is, okay, Mr. Stan, estate plan Stan, can you figure out a way that we can continue doing that?
Yes.
And the answer is yes, there is a way. And it's the same solution we had before. If you put this property, let's say you put a couple $100,000 in a bank account, you put the bank account into this asset protection trust I'm talking about.
Yes.
Well, when you put it in there, you put yourself on the hook for 5 years because you gifted it to the trust, right?
Right.
So whenever you want to make a gift to people every year, we use that back door that we talk about, that unlimited distribution of our principal to whoever we want to, out this back door. So we gift it to them out of the trust.
Yes.
That doesn't create a 5-year penalty period for us because we've already been on the hook for the whole thing when we gave it to the trust.
Right.
So we have a right to distribute it from our trust penalty free because it's not us giving it.
Right.
And there's there's nobody to punish. We already suffered our due punishment by putting it in there in the first place. Yeah. Remember I said if you put it in the trust, you're subject to the 5 rules. Mm-hmm. So 5 years. So once you put it in the trust, we take our punishment. You take our licks, and we're on the hook for 5 years. If we go in the nursing home in 5 years, they're going to impose a penalty period, right? Now, there's ways to get out of that, but I'm saying we're dealing with that.
Yeah.
So if we put it in there, and a year later we want to give a kid $10,000, if we give it to him from the trust, there's no effect of that because we already took our licks of 5 years by putting it in there in the first place. So you can continue doing this course of conduct that you like to do, gifting property to your kids.
Yes.
Had a woman that did that. I think she had 9 grandchildren. Every Christmas, $1,000 check for each of them.
Yeah.
What happened was when she went into care, and we argued that I might as well just continue with this.
Yeah.
TennCare said those are gifts.
Yeah.
Now, it's when you give stuff away, I say it's a presumption under the law. It's a presumption. It's rebuttable. The presumption is you did it to artificially impoverish yourself. So I made the argument. That, wait a minute, she's been doing this for 25 years.
Right.
Long before TennCare was even a glimmer, a spark in her thought process.
Right.
There was no foreseeability for this.
Right.
And I said, she's been doing that. So when she decided to go into long-term care and file for benefits, they look back 60 months and they see 5 years of these $9,000 gifts to each, $1,000 to 9 grandchildren.
Yeah, exactly.
And they're going to say those are, And so I say, wait a minute, this is a rebuttable presumption because she didn't do it to impoverish herself. She did it because she's always done it.
Right.
Nothing's changed.
Right.
Well, and then the argument came up, and the court actually said the argument came up. Well, but in the last 5 years, she was getting sick. She was diagnosed with dementia. It was foreseeable that she was going to go into care. Okay. So, and I'm thinking, okay, I actually won this argument, and this is what made it win. And I really, it's a tough thing to rebut. And I could probably count on 3 fingers how many times I've been successful with this. And so I'd rather just not argue at all.
Right.
And that's putting it in trust and making the distributions that way, the issue never comes up. But so the way I won that argument that was persuasive to the court was I went to the statute, and the statute says if you give stuff away, you're doing it for eligibility purposes. You are artificially impoverishing yourself, right?
Right.
And I said, look, this woman's estate is like $800,000.
Yes.
She's got a pretty decent estate. If she was giving property, these grandkids, for eligibility purposes, giving them each $1,000 a year isn't even putting a dent in it.
Right.
I said she'd be giving them $50,000 a year.
Right.
Then the state would have an argument that she's trying to impoverish herself. I mean, the interest on it even then covered what she gave away.
Right.
So, and that carried the day. But I don't want to rely on that because I think I was lucky on that, to be honest with you.
Yeah.
So that's what prompted my thought is how can we continue to do this for people who want to do it?
Yeah.
And the answer is put it in this asset protection trust and distribute it to the kids from the trust. The end result is identical, and it doesn't hurt us.
Yeah.
Because I'm finding this rebuttable presumption, the loop is closing faster and faster. The day is coming where you'll never be successful argument.
Interesting.
Because you can always say, in the last 5 years of going in the nursing home, you knew you were headed that way because you get there from degrading health.
Right.
I mean, the only example I can think of is if you're 100% healthy and you say, no, I'm not even worried about long-term care, and suddenly you stroke out in the middle of the night and you end up in long-term care. Right? I mean, maybe a scenario like that, but let's just do it so we don't even have to argue it.
Sure.
Let's do it right and take the rug right, pull the rug right out from under them, and just take the issue away from them to argue in the first place. So
we may have a question. Let's see if we do here this morning.
give me a chance to sip on my coffee.
Yes. Hey, good morning. You're on WDXE with us.
Yeah, I got a question about the trust. Son draws Social Security, and the way the will is set up, if he inherits, he's been disabled since he's just a child, but he's drawing Social Security. If he gets the inheritance, can he still draw Social Security, or if he puts that money in a trust, or does he just stop drawing Social Security and live off the inheritance?
That's an interesting
question. Before you hang it up and usually tell them that you'll listen, let me ask a question. You're talking, when you say disability, a documented disability, it sounds like it's SSI, Supplemental Security Income. Well, okay. Well, let's answer it, because I'm pretty sure that's what it is, because I think it said disabled from birth or something, or disabled as a child. There's two kinds of disabilities that we deal with routinely. SSI, Supplemental Security Income.
Yeah.
And, back before the late 70s, we used to call that welfare. But now we call it SSI.
Right.
And it's for people just like the caller described, somebody who, they have some sort of disability and cannot, take care of themselves.
Yes.
Or cannot fully take care of themselves.
Yes.
You can have all different kind of functionalities and stuff like that. But, or the other one is SSDI which is Social Security Disability Income, which it comes out of something that happens to you.
Yes.
Okay. Now, both of them are documented disabilities, and they come out of Social Security, right? Now, the question was, he receives that benefit through the Social Security, and if he inherits, is that going to quit?
Yeah,
I think does that sound like the question?
I think so.
Okay.
Yes.
And that's one thing is, your thought process is good because you're worried about that happening, and you're right. There's a scenario where that can stop, and there's a scenario where it doesn't have to stop. And we're shifting gears from that asset protection trust I was talking about.
Right.
But, there's a thing called a special needs trust. And this is what we call special needs person. And if you have a disability, you're getting government benefits. Now, there's a difference between the SSI benefit and the SSDI benefit, but we don't have time to go into that. But you are receiving government benefits when you're disabled.
Yes.
And you have to be eligible for those. Now, SSI has very similar eligibility criteria as going into long-term care, surprisingly enough. Meaning you can only own so much property, and they cap it at $2,000, just like they do at long-term care. So, you have to be eligible to get it.
Yes.
Now, the question is, okay, suppose Aunt Gertrude writes a will and says, I'm going to leave $20,000 to this child.
Yeah.
And so Aunt Gertrude passes away and she inherits $20,000. Have we just busted his eligibility? And the answer is yes. Yes. I mean, he's no longer resource eligible, and they will terminate his government benefits. And that's a problem because even though they don't give you much, I think it's about $972, I think is what it is. I don't deal much I deal with a lot with the special needs trust, not so much with the eligibility of stuff, but it's a set amount.
Yes.
And then SSDI is based on your disability, right? So even though we get government benefits, and sometimes they're not much, we really don't want to ever disturb those.
Right.
So if the person inherits money, they are going to be disqualified. And the way it works is, let's say Aunt Gertrude leaves you $10,000. Technically, if you still have that money, come the first day of the next calendar month, it's going to be considered a resource.
Yes.
And you'll be disqualified. And they do redetermination of those things. If they find out about it, they'll terminate.
Yeah.
Now, the bad situation is it takes a lot to get SSI and SSDI.
Yeah.
I mean, they turn you down like 3 times, and then they finally say yes. And it takes up 2 years to get through it, right?
Yeah.
And so you don't want to be in a situation where you've just terminated that, and now you have to, now you because here's the problem. If you get the $10,000 and you get terminated, well, now that's all you have is the $10,000.
Yes.
And you're not going to be eligible again for SSI until you spend it and spend it and spend it until you don't have anything left.
Then you have to do it again.
Now you're eligible again, and now you can apply, and you'll probably get it. But you got to go through all that. And it is, I mean, it's a headache at least, and it's a nightmare at most, right? I mean, it's not a fun thing to do. So what's the solution to that? If Aunt Gertrude says, "Well, I want to leave something to this child. I don't want to. The only alternative is not leave them anything."
Right.
Well, you can leave it to them. What we do is we create a special needs trust for that person.
Yes.
And a special needs trust can hold $1 million if you want it to. There's no limit to what you can put in a special needs trust.
Okay.
And a special needs trust is for that special needs child's benefit. He doesn't own it, and he's not the trustee of it. He has no control over it. But it's for what he needs. So the trustee of that trust can spend it on whatever he needs, and it doesn't apply towards their eligibility. So there could be $500,000 in a special needs trust.
Interesting.
And you say, you know what? The trust is. I want a place for this child to live. We're going to buy him a house.
Yeah.
You don't give the child a couple $100,000 to go buy the house because that would over-resource him and disqualify him.
Right.
So what you do is the trust buys the house for him and lets him live there. He still doesn't own anything. He still owns less than $2,000 because nothing in the trust is considered ownership to him.
Right.
He doesn't have access to it because that's a special kind of trust. And those trusts are pretty straightforward. They're creatures of statute. You can't get real creative in what you put in those, right?
Yes.
And so that's how we protect those benefits and still get an inheritance. So I guess coming to the actual answer to the question is that yes, he doesn't lose his benefits if the will says I leave $10,000 to Joey's special needs trust.
Yes.
That'll fix the problem. If he says, yeah, I leave $10,000 to my grandson Joey, the special needs child, that will bust his eligibility.
Okay.
So you're right to worry about it because if you don't do anything about it, he could. Now it sounds like there's already a will out there leaving property to that child.
Could be.
Maybe he talked about the
Very
will.
well could be.
Because something like the will says this, and so
Right.
if there is, it's a fixable thing. Create the special needs trust.
Yes.
Go to the person who drew up the will and say, would you please do another will? And instead of leaving whatever you're leaving to Joey, the special needs child, just change it to say it doesn't go to Joe, the individual. We're leaving it to Joey's special needs trust.
Yeah.
That is 100% cure of that. So now when you get all that money into the trust, it doesn't trigger a loss of benefits.
Yes.
We don't have to worry about, okay, this is all we have, and once it's spent down, we're now indigent again.
That's
you
pretty
still
good.
get the benefits.
Yeah.
And now they have when you're special needs, we now have this. There's a cap on $2,000. I draft into my trust that you can fund these things called ABLE accounts. If you got a child that is, you can have an adult that's special needs.
Right.
If you got somebody that has some functionality and they can actually work,
Yes.
but they can't earn enough to really be on their own. we have these ABLE accounts. It stands for Achieving a Better Life Experience, ABLE.
Yeah.
And it's for just that. It lets people work, earn money, and put it into this ABLE account without disqualifying themselves by having over the $2,000. And it's a self-esteem program, because people, when they get to work and do as much as they can,
Sure.
it's a self-esteem thing.
Sure.
And so, but it's capped. I think it's $15,000 a year and never to exceed a total aggregate of $150,000. But it is a neat program. It's a step in the right direction, that's for sure.
Yeah.
And so these special needs trusts allow the trustee of the trust to fund those.
Right.
And so that, the answer to the question is, if you haven't done anything, it's going to trigger a loss of benefits.
Yeah.
But the good news is we can fix it. It's 100% fixable.
Yeah.
So let's do that before the person passes away.
That's good advice.
Now if he does inherit some money, you got that calendar month to do something with it.
Yeah.
Which is not always easy to do because there's only a handful of things you can do with it.
Yeah.
So, good question and
Very
good thing
good
to
question.
be good thing to be concerned about.
Very good.
Because if you got a child like that, a thought that can wake you up in the middle of the night is, who's going to take care of this child if something happens to me?
We got a couple of minutes left. I think you might want to remind everybody about the seminar coming up May 18th at 10 a.m. here in the studios.
I will. And I noticed last week, I think the clock on the wall that I see was about a minute off from what the real time was. So
yeah, the real time I'm at.
I said I would wrap up a minute early this time because
we got a minute and a half.
Yeah, okay, I got you.
So
yeah, the next seminar coming up is May the 18th. It's a Saturday. We do those at 10 o'clock. You're going to do them right here at WLX, the back of the building, their Country Cafe. I'm warning you now, there's no sign that says Country Cafe. But find the WLX radio station, come to the back of the building. There's a set of double doors there.
Right.
You walk into a big room. Far into the room, there's a stage, and they pick and grin there on Friday nights, and people dance, and it's a real big place. So come to that. We call it Seminar Wills, Trust in the Nursing Home. And now we just briefly touch on that special needs. I sometimes do some of my radio shows. We talk about the special needs trusts and stuff. Yeah. So and we'll do that one of these days.
Yeah.
So come to the seminar. If you want to get RSVP'd for it, you can call my office at Pierchoski Estate Law, Pierchoski Elder Law at 931-363-7222, or you can go to my website, Estate Plan Stan. There you can get my phone number if you don't write it down. You can get my email if you want to ask me a question that way. You can see the calendar, and I think you can RSVP from the website for the thing if you want to. Or you can set up a phone call with me, schedule a phone call, or schedule a meeting, and we'll sit and talk. I mean, I'm glad to talk to people, but we get so busy that it's got to be scheduled and structured.
Right.
And the girls do that, and they run interference for me. You can come, you can talk to me, you can see me. It's just if you drop in the middle of something, you drop in out of the blue, it's hard for me to stop what I'm doing to do that. But I'm more than happy to make the time.
Much better by appointment, and you got devoted time. That's right. To look at your case. So have your conversation.
So it looks like we're right on about
Stan
15
Pierchoski,
seconds
everybody.
away.
Yeah, Stan Pierchoski, everybody. Pierchoski Law, downtown Pulaski, Tennessee. That phone number again, 363-7222. Good to see you, my brother.
Always a pleasure, Jeff.
See you next week.
Next week.
Prosecution from acts taken while president, referring to the federal 2020 election indictment. The Supreme Court will consider his immunity claim at a hearing